You were Alan Villasana.
Sir?
Mr. Villasana, you were charged with two cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine.
This courtroom moves fast, and today's docket is stacked with everything from theft, racing, and DWI cases to full-on family disputes and mental health evaluations. And right out of the gate, the judge isn't in the mood for excuses. Watch closely, there's a pattern in these hearings. Bold behavior, risky decisions, and defendants who underestimate how seriously the court takes public safety. Some own up, some try to talk their way out, and some, well, they dig themselves deeper. Let's break down what's really happening in each moment and why these rulings matter. Stick around. Some of these cases take wild turns.
Removed the security tape from a JBL speaker box and placed other products inside a shopping cart. The complainant proceeded to keep the surveillance on the mail and observed the defendant proceed to exit past all points of sale without any intent to pay the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. Both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was initiated.
So driving on the shoulder
Yes,
to
on
get.
the shoulder. A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
This is a classic situation judges deal with constantly. A defendant admits to racing at outrageous speeds, but tries to soften it by saying, "It's my first time getting arrested." The judge doesn't buy it for a second. Notice something important here. The judge immediately locks in on public safety. This isn't about minor speeding. This is 120 miles per hour racing, cutting off cars, driving on the shoulder, and literally admitting he would have kept running if he had more gas. That's a major red flag for the court. Judges look for honesty, but they also look for patterns, and admitting this wasn't the first racing incident puts them in a bad spot. What do you think? Should someone racing at 120 miles per hour get jail time on the spot? Or should the judge give them a chance, like this one?
You're not to go to any target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today, promising me you're not going to drive. And then you'll get with Felicia for your bond conditions.
I won't be able to come back. I don't have a ride.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since 5.
So, please. Good morning, Mr. Alipio.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60-mile-per-hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused, and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you were not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in this state will know to arrest you and put you in jail. Do you understand?
Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian ad litem?
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio.
Examíname, señor.
Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see
This moment shows exactly how strict courts get when someone is on their second DWI. The judge takes away his right to drive instantly. No debate, no negotiation. And here's why. Having alcohol in the car while driving, combined with a prior DWI, triggers automatic red flags. Judges see this as a major threat to the community. That's why he gets hit with multiple conditions: ignition, interlock, portable breath device, random testing, and zero tolerance for excuses. This is also where defendants often get confused, thinking they can drive with someone else or for work. The judge shuts that down instantly. Be honest, would you trust someone with 2 DW is back on the road, eh?
power to protect my street at all cost, and I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria where we will have you sign a reset. After that, you'll get with Felicia for your bond conditions, and after that, you'll be free to go. It's not forever, but I want to know that he truly appreciates and not just, oh, I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in any long time.
How do we know?
¿Cómo sabemos?
How many times has he not been caught that we just don't know?
No.
I don't know, but all I know is he's got alcohol in the car. He has a prior DWI, so he's already on notice of what you can and can't do. I have a problem. So
Yes, Your Honor.
just proactivity goes a long way.
Yes, Your Honor.
All right, good luck to you, Michelle.
You know, here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat and a serious bodily injury charge. Represent me.
Hi, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still don't think something's right with him. I talked to him.
So get a second opinion. You know, if you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, you know, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
no, he communicate. Just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no,
Yeah, it
if
doesn't
we're
work.
gonna, if we're gonna do this, we got to do it now. We have to decide if we're going to trial now. And
That's
then-
I want to get out as quick as possible and then
Kind of, but that was a little more than that though. Just,
talk to him.
I mean, I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception, maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his pending in the 220, this case?
No other cases pending as far as I know.
Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, you know, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it a court. I actually called my mom see if I could stay with her until she drops me off at court, and whatever they say from there, you know, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where you
plead
living
innocent.
now?
My mom stays in Tomball now.
No. Are you living on the street or are you living?
I'm homeless, but I've actually talked to my mom, and me and her are actually going into a good relationship now,
Did you just get picked up?
like mother and son. And yeah, um, you know, like they caught me at the airport, and
Look, I
know,
don't want you to talk about the case. The thing is that I don't want to continue to give you someone a PR bond if you're just going to go to the streets. The streets are not a safe
I
place.
won't go back to the street. The streets
I know.
aren't for me anymore, man. Like I don't want to be in the street. I don't want to be homeless anymore. And you know, I've talked to my mom. She's doing real good, and she actually wants me to be around, pay the bills, and you know, and own a house of my own. You know,
Let's do this. Why
after
don't we
her,
do
you
a
know.
TRAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate him to see how we go forward.
First,
If you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a TRAS to see where do we go? Because I don't know, but having clinicians talk to him might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. If he doesn't have a place to go to, or just, you know. Whereas if we have him TRAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, you know? So you just let me know whatever you want to do. I'm happy to do it.
And so just when we do the TRAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days, so he's not just lingering.
Judge, has his competency results cleared then?
Yeah, competent. Yeah,
Burr,
so we can get it done. And then that'll really tell us, perhaps he needs to be in mental health court. I don't know. But that's what you can get the TRAS for.
So what do you think, Judge, 2 weeks or?
No, not even a week. A week. Okay, thanks. All right, Mr. Flores. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he
Yes.
have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
Didn't,
Um,
no, I don't care.
He does not have any open
Nope.
cases
Okay.
at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria, while you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't pick up any new cases.
Yes, sir.
Is that pre-trial bond condition?
State's conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please? Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Anymore, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way.
You are Mr. Al-Bardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thomas
On
Flores?
March 12th, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness, who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant, and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Al-Bardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair Courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or Mackenzie? Begins any alcohol or any dope or anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria and then we'll have you take a seat in the jury box. Good morning, Miss Burse.
Sorry, I lost my voice.
Burse, that's what's right, right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13th, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and recorded the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat, floorboard, and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming this complainant doesn't want to have contact with her?
We do not have, we have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well.
Okay.
If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then no.
You need a lawyer.
Okay, then
You're facing 6 months in jail,
then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
Yes.
It's a good idea. Do you mind giving her an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign them. And then
Okay.
I'll have you talk to a lawyer here momentarily. All right. Good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we
Bill
talking
Buckley.
like tons of text and stuff? How many are we
Yes, sir.
talking?
Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond, put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right?
So,
All right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
yes.
Okay, so what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it and then you'll be free to go. All right, please. Good morning, Mr. Runyon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on the 22-800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location. So the witness drove to the main roadway near his house and observed the sofa had been dumped at an abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road.
Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
So
Right.
I would just request, this is not with us, this is with environmental. I would just request we hold off on PC reading until the prosecutor hears it's based on.
Okay, I mean, I'm willing to hold it, but you know,
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does, and he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it,
Gotcha. Would you like him brought up,
Just-
Judge?
please.
Okay. Mr. Thomas?
Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and defendant then exchanged in a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I
To start
understand.
getting into more stuff, I mean, my only concern is, was there a terroristic threat, right?
Exactly,
And I
exactly.
don't know, it looks like there were potential multiple threats. So which one is in the charging instrument? Is
I think the one alleged to have occurred
on the actual day in question when everything,
I can look and
Yeah.
double check.
because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, you know, he had told them, don't upsell me, don't upsell me. He comes around the corner and the guy's in his car. So that's why they gave him the discount on the receipt.
but I mean,
Even so,
Did-
Your Honor, a discount was a discount what happened.
No, I understand.
And just to clarify, it is the first threat on
first
January
threat.
18th.
Yeah, I mean, it's,
It is what it is. I understand.
so Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute
5-minute oil change.
Yes,
The
sir.
5-minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can.
Also ask for no contact with the complainant.
Of course.
We'll fix it. Alrighty. Anything further, Judge?
We have to do bond.
Oh, I'm sorry.
Um,
This is.
bring me out a PS. Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right.
Yes, sorry.
So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much, Judge.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with police for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, Judge Powell, do you
Yes, sir.
attorney of record, please?
Yes, sir,
We
certainly.
have him over there in the tower.
Okay, thank you.
Judge, I need the.
Sir, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right for trial.
Sir.
Held witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
Yes.
Is it true
¿Es
or
verdad
untrue that you
o
had
no
a
es verdad
5 or
que
above?
tenía un 215 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí,
¿Verdad o no verdad?
verdad.
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI, not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
¿Lo entiende?
Yes, sir.
All right, good luck.
Thank you, Judge. Have an excuse?
Ven aquí.
Thank you.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardan.
Okay.
BARDAN.
So you got appointed Mr. Albardon?
Yeah.
Great, okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's, Mr. Albardon, come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
The only, so, Mr. Albardon, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no
Okay, I
threatening
thought
or
we just
harassing.
wait right there not to leave.
Okay. Stay.
Last name is Bledsoe.
Bledsoe. Okay. You want to bring him on? Are we going on the evading and the terrorist act that's going to be dismissed? Good morning, Mr. Bledsoe.
Come on.
You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Yes, sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Good, sir.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna, we have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are,
Sorry.
it's okay. No, and I think you're right, we were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
So, not saying this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question then for the board, and with, I'm not saying I'm gonna do this on this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury? I mean,
You can, of course you can.
So,
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As far as me, I'm going to just hold to the standard that we agreed with the county and the lawsuit.
Yeah, I'm just, and this is for my own.
And you, look, you're not going to hurt my feelings if you go to a grand jury. I don't
I know,
care.
I know you, Judge.
Oh, really?
I just, so we wouldn't be held to that same
You need
standard.
to
at grand
do,
jury.
you need to do what you think is right.
Okay.
Like I'm going to do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did, you know? Not everybody is,
I understand.
which is good.
Thank you.
God love you.
Good morning.
Is it? All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we
it.
are doing, we're working on a PTI with the,
Quicker you get it done,
that's what I'm saying, with,
quicker it is for you.
they do want to test as well as a condition, so, once we test them again, then we get submitted.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Yes, Your Honor.
I'm going to find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes,
Don't say anything. Just please,
understand.
keep it nice.
Today's courtroom was a full mix of everything: racing, theft, DWI, domestic disputes, mental health concerns, and even illegal dumping cases. But the judge's message stayed consistent across every situation. Public safety comes first. Whether it was taking away driving privileges, issuing protective orders, or giving conditional freedom, every ruling came down to one thing: preventing the next bad decision before it happens. Some defendants cooperated, some pushed the limits. But every case carried a lesson about accountability and consequences. If you found these cases as eye-opening as we did, hit that like button, drop your thoughts in the comments. And don't forget to subscribe for more real courtroom breakdowns, deeper analysis, and shocking moments caught on camera.
We're getting more toward a kidnapping.
Oh,
type.
no, to like say it's an unlawful seizure, like, there's, we were comparing versus, it's not because it's a private actor, but I'm saying, hey, even if it is a private actor, if it effectuates what a cop would be doing, it would fall under the same tenets of, unlawful search and seizure, and so.
Certainly interesting.
Yeah, I don't think we're gonna get there, though. I don't think we're gonna get there on this one. I don't think we're gonna get there on this one. It's,
Theory's wonderful,
Makes the show fun.
so,
What you got?
Mr. Lázaro Echemedia.
It's old.
Yeah.
What do you want to do?
So we're set to plea or set it for trial today.
Correct.
I see some issues in the case. I've talked to my client. He is interested in possibly doing something different, but he is,
I mean, what other
we
different?
need an immigration consult, well, possibly time served. But the thing is, the holdup is, I need an immigration consult.
That should have been done beforehand. I mean, today we're set plea or trial. This is not.
Right, and the only thing is,
No, we're now 215 days.
the thing is, I was only appointed like a month ago. I saw all these issues over the weekend. And so talking to him, see if he wanted to go to trial, he's like, hey, hold on, let's get an immigration consult, see how it's going to affect me. So
Okay, so I guess I'll give him till Monday.
the only thing with that is, Judge, this consult goes through the MAC. It's Miss Julie Pash. Today is Thursday. She's been getting on me about how backed up she is lately.
It's 215 days old, dude.
Get it?
I mean, it should have happened a long time ago.
Right.
You know, you can't just, it's on him. It's not on you. It's on him.
Yeah, I'll be straight with you, Judge. I don't know why I was only appointed like a month ago. I don't know if he was missing or something.
Correct.
was
He's been
missing.
AWOL from that.
Ah,
So it's not, I mean, I'll give you a week, but that's it.
okay, I'll let her know. I'll let her know and hopefully she gets it done. Thank you, Judge. All right. Okay.